Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2, Jefferson County, Texas. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. First of all, I'd like to welcome you to County Court at Law Number 2. The reason why you were asked to come here this morning is because you have a case in this court. Now, the cases that we handle in this court are classified as misdemeanor cases. Criminal cases are divided into either felonies or misdemeanors. Your felony cases are known as your more serious type offenses, and your misdemeanor cases are referred to as petty offenses. Does not mean that they're not serious. They're just not as serious as the felony offenses. Now, if a person had a felony offense, they can be sent to the state penitentiary. If you have a misdemeanor offense, you cannot be sent to the state penitentiary for your misdemeanor offense. However, your punishment can require you to be sentenced to the county jail. Now, if you have a felony offense, and it was felonies are divided into various categories. It either could be a capital murder, first degree felony, second degree felony, third degree felony, or state jail felony. State jail felony is the lowest felony. The highest felony is a capital murder. If a person is found guilty of a capital murder, they can be given life or death. If they have a first degree felony, they can be sentenced to 5 to 99 years in the state penitentiary, 5 to 99 years to life in the state penitentiary, or fined up to $10,000. If they're convicted of a second degree felony, their punishment can be anywhere from 2 to 20 years in the state penitentiary, fine up to $10,000. If they're sentenced or found guilty or convicted of a second degree felony, the range of punishment is 2 to 20 years, fine up to $10,000. If they have a third degree felony conviction, the range of punishment is 2 to 10 years, fine up to $10,000. Or if they have a state jail felony conviction, their punishment can be anywhere from 6 months to 2 years in the state jail, fine up to $10,000. And as I said earlier, for a misdemeanor case, a misdemeanor conviction, you cannot be sentenced to the state penitentiary. However, your sentence could include you being sentenced to the county jail. Now, misdemeanor cases are divided into 3 categories. It could be a Class A misdemeanor, Class B misdemeanor, or Class C misdemeanor. Your Class C misdemeanors, you cannot be sentenced to jail for a Class C misdemeanor. You only could be given a fine. And your Class C misdemeanors are handled in the Justice JP court or the municipal court. Now, if they appealed from any one of those courts, then they come to this court, and we still cannot give you jail time because the punishment range will only be a fine. For example, a Class C misdemeanor is like a speeding ticket. That's normally as a Class C misdemeanor is not wearing a seatbelt. Cases like that, you can only be given fines and not jail time. Now, for a Class A misdemeanor, which is our highest misdemeanor in Texas, you can be given time punishment in the county jail anywhere from 0 days all the way on up to a year or anywhere in between, a fine from $0 to $4,000 or anywhere in between, or you could be given both such fine and confinement. For a Class B misdemeanor, your range of punishment can be anywhere from 0 days to 6 months, which is 180 days in the county jail, or anywhere in between, a fine from $0 to $2,000, or anywhere in between, or you could be given both such fine and confinement. Now, you may qualify for probation. There are 2 types of probation. One type of probation is called adjudicated probation, and we normally refer to it as regular probation. The other type of probation is called unadjudicated probation, and we normally refer to it as deferred adjudicated probation. The difference between the 2 is as follows. If you have a deferred or unadjudicated probation, it does not result in a conviction on your record. And if you successfully complete probation, case will be dismissed, and you may qualify for what we call a non-disclosure. Non-disclosure means that we cannot tell the general public that you were on deferred probation for that offense. If you violate the terms and conditions of your deferred probation, then what can happen is The state can file a motion to revoke your probation. If a motion to revoke your probation is filed, you'll be entitled to a hearing. And if the judge finds that you have violated your probation, then your probation can be revoked. If your probation is revoked, you may get a conviction. And if you get a conviction, obviously, the case is not going to get dismissed and you can't qualify for a non-disclosure. Now, for the regular probation, it does result in a conviction on your record. That's adjudicated probation. It does result in a conviction on the record. However, there is something that is called judicial clemency. That what that means is that the court or the judge can set aside that conviction. But in order for that to happen, a couple of things need to take place. First of all, you have to successfully complete the probationary period. And second, your probation has to expire, which means you cannot have any more time left on your probation. And then third, the third thing that will happen is the court can discharge you from probation, successfully discharge you from probation. If those three things happen, then the court can allow you to come back into court, withdraw your plea of either guilty or no contest, and then the court can dismiss any complaint, affidavit, or information that has been filed against you, and then the court can set aside the conviction, which means you will no longer have a conviction. And you could truthfully say that you wasn't convicted in this case. However, if you get a subsequent conviction, meaning that if you get another conviction later on, then they can bring the case back up that you got judicial clemency on, and it could be used against you. If you try to get a license with CPS, they can deny giving you a license, or if you have a license, they can revoke or suspend the license that you have. Now, you'll have an opportunity today to enter one of three pleas. You could enter a plea of not guilty. If you enter a plea of not guilty, you're telling the court that you did not commit the offense that you have been charged with. Or you can enter a plea of guilty, and if you enter a plea of guilty, you're telling the court that you committed the offense that you've been charged with. Or you can enter a plea of no contest. No contest means that you will not be fighting or you will not be contesting those charges. Now, as a defendant in a criminal case, you have three options. Number one, you may hire an attorney. That's first option. Second option, if you do not have enough money to hire an attorney, you may request an attorney to be appointed to represent you. Or number three, you may represent yourself. You could choose one of those three options. If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney or representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. You will be handed a form with this information that I have just read to you. And at the bottom of that form, it states, defendant's choice, mark initials next to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you will put your initials on the first line to the left. If your choice is, I have hired an attorney whose name is, then you will put your initials on the second line to the left and the name of the attorney on the line to the right. If you want to apply for a court-appointed attorney, then you put your initials on the third line to the left Or if you have already been appointed a court-appointed attorney, then you'll put your initials on the fourth line to the left and the name of the attorney on the line to the right. Now, if you want to waive your right to an attorney and represent yourself, then you'll put your initials on the fifth line. And then you'll sign at the bottom of that document where it says defendant, and you will place today's date, September 28th of 2021. For those individuals who will be waiving their right to attorney and representing themselves, then they will also have to sign the second page, which reads, waiver of counsel for purposes of entering a guilty plea or proceeding to trial. And it states, I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 28th day of September of 2021 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that's your choice, then you will sign on the line that says defendant, and you will place today's date on that document, which is September 28th of 2021. Now, as a defendant, you also have other rights. You have a right to have a trial by jury. For those people who are sitting in our that area over there, we call that the jury box. What a jury is, the jury will decide, they'll be selected and listen to all of the evidence in your case, and they will decide whether or not you're guilty or innocent after listening to all the evidence in your case. You also have a right to waive, which means you also have a right to give up a right to have a trial by jury and just have your case come before the bench. And if your case comes before the bench, what that basically means is that you will not be having a jury trial. The judge will decide, your case will come before the judge either in one of two ways. It will come before the judge either by a trial, we call that a bench trial, or it could come before the judge by a plea. If you enter a plea of guilty or no contest, you can come before the judge, and then in one or two ways, you could either have an agreed plea bargaining agreement. That means that if you and the state has reached an agreement to settle your case, that's an agreed plea bargain agreement. The judge does not have to follow that agreement. However, if the judge does not follow that agreement, then you'll be entitled to withdraw or take back your plea. Now, if you come before the judge on, and y'all don't have an agreement, when I say y'all, I'm talking about you and the district attorney, you have not reached an agreement, however you want the case to be disposed of, that you're basically stating that you want the judge to decide what the punishment will be in your case. We call that an unagreed plea. Now, you also have a right to have witnesses to come to court. Witnesses, they can testify for you or against you. You could ask them questions. We call that either direct examination or cross-examination. You also have a right to waive or give up your right to have witnesses to come to court. And by doing so, you will not be calling any witnesses on your behalf. However, the state will be calling witnesses in the case on their behalf. Now, the next thing, you have a right to what we call it a Fifth Amendment right. You have a right not to testify in your case. We call that a right against self-incrimination. And with the right against self-incrimination, that simply means that you have a right not to testify in your case. Now, you can waive or give up that right. And if you waive or give up that right, then you'll be saying that you want to testify in your case. You'll be waiving or giving up your right against self-incrimination. You also have a right to see the evidence. And what the evidence is, we call that you have a right to have discovery. And discovery is you have a right to see the evidence that the state has against you in their case. You have a right to see the documents, videos, witness statements, whatever evidence that you have a right to have access to that, either if you're representing yourself or Your attorney will have access to it if you have an attorney that is representing you. Now, I mentioned earlier that you'll have an opportunity, you can enter one of three types of pleas, either plead guilty, or you can enter a plea of not guilty, or you can enter a plea of no contest. If you enter a plea of not guilty, again, you're telling the court that you did not commit the offense that you've been charged with. Or if you enter a plea of guilty, you're telling the court that you committed the offense that you've been charged with. Or if you enter a plea of no contest, you're telling the court that you will not be contesting or you will not be fighting those charges. Now, for every day that, everyone that's here have been arrested on their case. That means you booked in jail and you booked out. Every day that you spent in jail, you could get credit on that toward your punishment. So for example, if you spent, I'll just pick a number, say 5 days in jail, and let's say the state is offering you 5 days in jail, then you can get credit for the 5 days that you've already spent in jail towards your punishment, which means you'll be given credit for time served, which means you won't have to serve any more time on your sentence. However, if you have more than 5 days, if they offer you more than 5 days, if they offer you 7 days, that means you have to serve 2 days. Now, every day that you spent in jail is credited as $100 per day that goes towards your fine and court costs. So if the state is offering you a fine of $500, fine and court costs of $500, and you spent 5 days in jail, you will not have to pay anything because the 5 days in jail is equivalent to $500. So therefore, the fine will be what we call taxed and retired. You will not have to pay it. However, if the state is offering a fine and court cost of $700, then that simply means that you have to pay $200. Now, if you can't pay the fine, if you have a fine that the state is offering, and if you can't pay that fine that day, then we can give you time to pay it off. In essence, we can reset it for another day for you to pay it, or we could put you on what is called a payment plan, so you can pay it off. But let's say you cannot pay the fine at all, even if we put you on a payment plan, then what we can do is we can convert the fine and court costs to community service. Now, every hour that you perform in community service, $12.50 will go toward your fine and court costs. So if you work an 8-hour day, you do 8 hours of community service, that's $100 that will go toward your fine and court costs. Now, the state has a program that is called pretrial diversion. When I say the state, I'm talking about the district attorney's office. They have a program that is called pretrial diversion, and it's for first-time offenders. And basically what happens is if you get into the program, your case is dismissed. And if your case is dismissed, you can get it expunged. Expunged means you wiped off, deleted, or erased from your criminal record. And the way the program works is, first of all, you have to get an attorney to help you get into the program. Next, you cannot have a criminal history. It has to be your first case. And then the third thing is, it doesn't apply for cases that involve unlawfully carrying a weapon or resisting arrest. It applies for all other cases. Now, if you get into the programs, case is dismissed, you can get it expunged, wiped off, erased from your record. Now, if you are a veteran of any one of the branches of the military, the state has a program that is called Veterans Court. And if you get into that program, the case is dismissed, and you can get it expunged from your record once you complete the program, and that's for veterans. It's called Veterans Court. This court, County Court at Law Number 2, has a program that I started in March of 2017 that is called the Community Safety Initiatives. Normally, we call it the CSI program. That program is designed to make Jefferson County a safer place for all of us to live, work, go to school, go to church, raise our children. And the way the program works is we address the issue of what we call recidivism, where people commit crimes over and over. And so the way we stop that is through this CSI program. We have partnerships with agencies in our community. We have a partnership with Spindletop. Spindletop is our local mental health agency. And Spindletop also has a program that is called ATAR. ATAR stands for Addiction Treatment and Recovery. It's a drug and alcohol recovery program. And we have, with the Spindletop program, with the mental health side, we have mental health counselors that's in court. They will do private interviews, and Spindletop can develop a treatment plan, do an assessment, develop a treatment plan, either outpatient or inpatient treatment for individuals to address the mental health needs of individuals. The other thing is, if a person has a problem with drugs or alcohol, ATAR is a program that they have at Spindletop. I think they have a youth program. And then they also have a program with Ozar. Ozar has a program where they can come in like Spindletop, they can do an interview, a screening, and they can develop a treatment plan, either outpatient or inpatient, for individuals that have issues with drugs or alcohol. Now, if somebody is unemployed or they have a job and they want to get a better job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University, and Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training program in the hotel industry, the shipping industry, and the chemical industry. You'll be trained in one of those areas that you choose, and once you're trained in one of those areas, they will assist you at getting a job in the area that you train in. If you have not graduated from high school, then the CICE program at Lamar has a GED program. With the GED program, they can help you to get your graduate equivalency diploma. And all of these programs that I have just mentioned are free. They do not cost you anything. And the other thing about the program, all of these programs can be used as community service toward your punishment. So for example, let's say you were ordered to pay a fine and court costs, but let's say you cannot pay the fine and court costs. But let's say you want to get some job training. And once you do the job training, every hour that you spend in the classroom, 1 hour will go toward your community service, and $12.50 will go toward your fine and court costs. So you're doing one thing, but you're getting credit for three things. The three things is you're in the program, you're doing community service, and you're paying your fine and court costs. I say it like this: you're killing three birds with one stone. Okay. Now, these programs, as I said, they are programs that are started here in County Court at Law Number 2 within the first 100 years of being in office. And I tell people this all the time: when you come to County Court at Law Number 2, we don't have court as usual. We have unusual court. It's not because we're different, but it's because we're trying to make a difference of the lives of the individuals that comes before this court, and we're trying to make a difference in Jefferson County. Also, this program is designed to produce productive people. We believe that producing productive people, then it makes our community safer, because productive people, for the most part, do not commit crimes. Why? Because they have too much to lose. All of these programs, I said, are free. It does not cost you anything. Only thing you have to do is have a desire to be in the program. Now, we have Jess, who is with Spindletop. Jess is going to come up and tell you a little bit about the program that they have to offer at Spindletop. Jess?
Hello, my name is Jess, and this is my co-opportunity. We're qualified mental health professionals with Spindletop. We are here today because the judge has asked us to come before you and speak to you. If any of you have any substance use or mental health problems you would like to talk to us about, we have found that a lot of people that cycle in and out of the court system and the justice system in general have those types of issues. And if you would like to seek treatment for that, we're here to help you with that. Everything that you say is confidential and HIPAA regulated, so as Kennedy and I are going around talking, if you would like to talk privately in the back, we're gonna give each of you one of these pamphlets, which has the crisis hotline number. If you or anyone that you know is in a crisis situation, you need help, you can call them, or you can call 911. It's also got some more information on the back if you need it, and we'll also have these cards. If you don't want to talk now, you want to talk later, you can give this to us, or if you do know somebody else that's also struggling with some issues, you can give this to us and we can call you back another time, get some more information for them as well. Are there any questions for me right now? All right, thank you.
Okay. Thank you, Jess. Now, ladies and gentlemen, what we're going to do, we need to pass out some paperwork to you. Earlier, I told you you had 3 options. You could either hire an attorney, you can see if you qualify for court-appointed attorney, or you may represent yourself. And we'll get those forms to you. So it's going to take a little time, so just be patient with us. And we'll get the forms. We'll give you the form, the ink pen, and then we'll have something for you to write on. So, okay. So just sit tight. And then once you finish filling out those forms, we'll pick them up. And if you need to like take a break or something, you can go out into the hall and take a break, but do not leave the courthouse, because if you leave the courthouse, then your bond will be forfeited. And if your bond is forfeited, a warrant shall be issued for your arrest. Okay? So just be patient with us so that we can get that information passed out to you. Just hold on a minute. We'll be able to answer your questions. Yes, we will. Okay, so we'll be in recess. Now, ma'am, I see someone on YouTube, on our Zoom. Would you please state your name?
Francis Morrell.
Morrell?
Yes, sir.
Do you have a Francis Morrell? How do you spell your last name?
Morrell.
Did you look that up? Francis Morrell? I don't see it on this docket. Just hold on a minute.
Okay.
Oh, okay. You're supposed to be here today at 1:30. It's set for trial. Get in contact with your attorney.
Okay, because he told me we could do Zoom today. I didn't have to show up.
No, just get in contact with your attorney.
Okay. Thank you.
Okay. All right. You're welcome. You have a blessed day.
You have a blessed day too.
Thank you.
So just hang up.
Okay, we'll